This is file number 25760FY, People versus Kuran Fuller. That's you, sir?
Yes, sir, it is.
You're here with your lawyer, Mr. Ross Truckee.
Yes, sir, I am, John.
This matter is set for a pre-exam conference this morning. It's got some history to it. It was set for a preliminary examination on the 20th of May, I believe the date was, and you didn't show up. So you should have bench warrant for your arrest. You presented yourself in court on the 28th, and I recalled the bench warrant and scheduled the matter for this morning. I asked for a special hearing regarding Assistant Prosecutor Attorney Gary Gabri. His boss, Deborah Davis, is here. Ms. Davis, is Mr. Gabri going to be present?
Your Honor, he's next door doing the sentencings with Judge Pattison. So it wasn't clear from the email what exactly we were going to be covering.
He was extremely disrespectful to me. He walked into my chambers, called me disgusting, stomped out and disagreed with my recalling the bench warrant in this case, which is a violation of the canons of professional ethics and a great insult to me. He also was wrong on the facts and the law. So he needs to be here and he needs to be prepared to apologize to me. And I'd like to make a special record with him present. If he feels he can come into my chambers and insult me and then stomp out because he disagrees with my ruling, he is sorely mistaken. So I want him present if we can proceed.
We can certainly deal with that issue.
One eternity later.
Your Honor, Mr. Gabri is willing to come in and speak with the court. We would ask that it be off the live stream. It can still be an open courtroom, but we would ask that it not be streamed.
All right, thank you.
Thank you.
One eternity later.
I don't know what we're waiting for.
We're waiting for Mr. Gabri. I'm
Is
not
there
sure.
another hearing in a different court?
I'm sorry.
I thought it was done.
He is, I guess I was hoping the court would address.
No,
that.
I'm not doing it in chambers and I'm doing it on a live feed. If he doesn't wish to be here, we'll make a record. I'd like him to be here. He had a position he wanted to state. I never got a chance to explain my position. So no, if he doesn't wish to be here, then I'm gonna proceed accordingly.
As far as Mr. Fuller's case, is there a drug test?
Well, I called. We'll address that when everybody gets here. We can't do an instant drug test because we don't have a male certified to do it. We only have Autumn. So I'm going to send him to the day reporting center directly from here. There's a condition of your bond that you test on demand of any police court officer. The prosecutor is asking for a drug test. I would prefer to have done an instant one. We did one yesterday, which we're going to deal with in a minute, but I don't have the ability to do that. So when we finish here, you're going to go directly to the day reporting center and test, and then we'll deal with the results of your test either when we get them or at the time of the prelim, which is set for next Tuesday at 1 o'clock. All right, good morning. Mr. Gabri is here, and we're going to proceed. This is in the matter of People versus Kuran Fuller. Oh, yeah, good. Thank you. Thank you, Deborah. Laura came in to check. This is in the matter of People versus Kuran Fuller. Mr. Fuller is here with his lawyer, Mr. Ross Truckee. Also present is Assistant Prosecuting Attorney Gary Gabri and Prosecuting Attorney Deborah Davis. Mr. Fuller was charged in April with being a felon in possession of ammunition. I believe that alleges he had 2 shotgun shells. Anyway, because he is a felon, he's not allowed to possess ammunition, and the matter was charged as a felony. He is on bond on 3 other felony cases, which are all bound over to the circuit court. And he was charged with this. Judge Pattison set the bond at $10,000 cash or surety with certain conditions, including supervision of the Community Corrections Office and drug testing. The defendant was here on, I believe, May 13th for a pre-exam conference with Mr. Truckee and indicated at that time he wished to have a preliminary examination. So the preliminary examination was set for May 20th. And I'm going to represent what I was told so anybody can correct if it's different. At any rate, the defendant didn't show up on May 20th. Police officers were here prepared to testify, much to the consternation of all of us, including me. So I issued a bench warrant and set bond at no bond. I wanted to see you personally. Then I went on a trip. I came back on Tuesday, May 27th. I believe it was, this occurred the following day. I may have my days mixed up. I thought it was Wednesday, the 28th. At any rate, there was a warrant out for Mr. Fuller's arrest for failing to appear at that hearing. He called the court that day after the 20th and said, in the afternoon of the 20th, so I missed my court date. And they said, well, there's a warrant for your arrest. Between the 13th and the 20th, Mr. Fuller came into the court and paid some payments on a payment plan that he was on for some other cases. So between the 13th Tuesday and 20th, they didn't show up. He was actually in the courthouse and paid on some fine. So he didn't show up on the 20th. Then he presented himself at the court. Now, Mr. Truckee or Mr. Fuller, you can fill in the details here. My understanding is Mr. Truckee told him to turn himself in at the jail. Rather than meet him here at the courthouse, Mr. Truckee was here that morning. He told him to turn himself in at the jail. My understanding is, and correct me again if I'm wrong, he went to the jail and sat there for about 45 minutes, but they said they were too busy to book you in. Is that true?
Yes, sir, Your Honor. So
So you came from the jail to here. So I'm in the middle of a busy morning with a bunch of other stuff going on, and here you are. So you walked, Mr. Truckee walked out the door, you walked in the door. So he was gone. We tried to call him, but he was already on his way to Three Rivers. So here you are. I canceled your bond. It was my bench warrant. And there's a statute that nobody likes, but it's MCR 6.105. It's actually a court rule. If a defendant wanted on a bench warrant or arrest warrant voluntarily presents himself to the court on that warrant within 1 year, the court must either recall the warrant and schedule the case for a future appearance. It is presumed that the defendant is not a flight risk when the court sets a bond order or other conditions of release at arraignment. So that's what I did. There was another option. You can arraign the defendant if the court is available to do so within 2 hours of the defendant presenting himself. So he'd been to the court between the dates. He called the court the date he missed. He went to the jail to turn himself in. They wouldn't accept him. So I went with option 2 of the court rule, which allows him to be presumed to not be a flight risk and appear, which he did. Mr. Truckee was scheduled to be here this morning. He was late. He did call and said he was running late, but he's here. I didn't give him a PR bond. I simply recalled the warrant and reinstated the $10,000 cash or surety bond that was in effect. So it's like, okay, no counsel was here. Mr. Stickley wasn't available. Mr. Truckee had left. I didn't give notice to the prosecutor. I simply scheduled the matter for this morning. And then went on back about my business because I had other stuff to catch up from being on vacation. So some point later that morning, Mr. Gabri came into my chambers. I was in there signing some orders and I said, hey, good morning. I got something I'd like to talk to you about. I had a misdemeanor complaint that was handled by their intern that I wanted to check with them on. And he said, I have more important things to talk about than that. And he said, why in the hell would you give Kuran Fuller a PR bond? And I didn't have an instant response. I just recalled the bench warrant. And then I said, well, I guess I'm sorry I didn't give you notice of the proceeding, but he just showed up and I cited the court rule. So I set it for today. So Mr. Gabri was quite upset. He got up and either said, this is disgusting or you're disgusting. And he walked out of my office. And this was ex parte. Nobody else was in there but us. And so I left sitting there thinking either me, now maybe the statute is disgusting or court rule that there's a presumption if they turn themselves in that they're not a flight risk. If I had done that when I was assistant prosecutor to Judge McManus, Bob Karras would have fired me that morning. When did it become a thing that the assistant prosecutor could come in and tell the judge that he's disgusted by a ruling that he made? I'm not sure when that became appropriate. I don't believe you do it to Judge Stutzman. I don't believe you do it to one of the judges in Kalamazoo. I followed the law. I had an understanding of the facts. I followed the court rule. I set the matter for hearing. He's here today. The offense he was released on was possession of 2 shotgun shells. I don't have the discretion to cancel this bond because Gary Gabri is mad at him. And I didn't deserve what you came in and said to me. In my career as judge, you've been the most disrespectful attorney to me, bar none. An attorney came to me after a hearing and said, how long do I have to be a lawyer before I can be as much of an asshole as Gary Gabri was to you? I don't deserve that. And I didn't deserve this. I followed the law. I had a better understanding of the facts than you did. I had a better understanding of the law than you did. And he's here now. Make a motion to cancel his bond in circuit court if you're that upset about it. I'm going to send him for a drug test here before we're done this morning. This violates the canons of professional responsibility. You have an obligation to treat the court with respect and your other lawyers with respect. And I understand that you were upset, but you left before I even got a chance to explain myself. So that isn't a thing. The assistant prosecutor can't go into the judge's office and say, your ruling sucks. That's not how it works. So I didn't deserve it. I don't deserve it. And I believe I was right. And he's here now. We're going to have a drug test. You have your right for a preliminary examination, which will be next Tuesday at 1 o'clock. And we'll proceed accordingly. So what I expect is you to apologize. I understand that you lost your temper and you're upset about it. And that's to be understood. Nobody liked Court Rule 6.105. It was very controversial with the judges. You either had to let them go or drop everything you're doing and arraign them within 2 hours. And as I said, he had turned himself in at the jail and they wouldn't take it. So I set it for this. So that's all I have to say on the matter. Ms. Davis.
Thank you, Your Honor. First, I would like to say that we were not aware of Mr. Fuller attempting to turn himself into the jail. But that's the first I've heard of it is today. We'll certainly be following up with that. Our belief is that the bench warrant arraignment is a critical stage and that he should have had an attorney. We had made it clear at the last hearing when the request was made that we felt that Mr. Fuller was a continuing risk. He was involved with felonies. He's not new to this system. He knows how this works. He knows where he's supposed to be and when he's supposed to be there. His pattern of behavior towards law enforcement is extremely dangerous with fleeing and eluding and resisting and obstructing. And in order to protect society and give our law enforcement the support that they deserve too, we were asking that his bond be canceled and that he be remanded. The concern is now that he continues to be around people who use substances. So his history and not showing up, I'm thankful that the court is going to have a test done.
Well, let's assume that all that is true. What gives him the right to come into my office and express his disgust for my ruling.
Your Honor, I don't believe that it's not appropriate. I get that. We are in a very difficult situation in our office in light of everything that has happened in the last year and a half. So it's been very difficult. It's been very stressful. And I think overall, Mr. Gabri has the same philosophy that I do as far as holding people accountable and, you know, taking action so that people know that if they do get in trouble, we're going to hold them accountable and not just allow people to waltz in as, you know, when it's convenient for them. It's not convenient for any of us. And, you know, we do our best to have somebody available at all times so that if there is an emergency hearing, the court can call down and we will get somebody here. So what happened, the way it was described to me was different than what.
Well, there's two sides to every story.
Correct, and there's perceptions. So I know that Mr. Gabri apologizes for the.
I don't want to hear it from you. I want to hear it from him.
Well, I understand it. We'll give him a chance to speak in just a moment, but from the beginning, it was my understanding that the comment was made as far as the whole process, because we feel like we're doing our best to charge, hold people accountable, and show up whenever we can.
Well, we've got a case where he's charged with possessing 2 shotgun shells.
Which
Move
is,
to cancel his bond in circuit court. If you could, I don't want to hang my nail on canceling a bond for someone who was here in between, called the court, went to jail. And the law doesn't require that I give notice to the prosecutor. I had one of these yesterday. I have one almost once a week, somebody shows up. So he's here. You're right. He keeps doing stuff. Or try one of the cases. He's got 3 cases bound over to circuit court. He got charged with a crime, got arrested again, no motion to cancel his bond in circuit court. We set his bond at $10,000 cash or surety with conditions. So it isn't like we're just saying, you know, please don't do this. But it would have been an abuse of my discretion to cancel his bond for not showing up on a case where he possessed 2 shotgun shells. So I set it for this hearing. And he's here, and we're going to drug test him. And you can have a prelim next week.
thank you.
Mr. Gabri.
First of all, let me say without any equivocation that I apologize for losing my temper, for addressing you more as someone that I have known for my entire career in criminal justice, someone who with me taught a number of even elected prosecutors right now how to try a case, how to be a prosecutor, what the ethics are involved in prosecution. In my 45 plus years, I have never been held in contempt. I have never disrespected the court when on the record. I have always prided myself on not only doing the right thing as a prosecutor, but also protecting the community's interests and law enforcement's resources. The comment that I made to you would never, Your Honor, and I think you know this because you and I know each other, our wives know each other, we've spent time on Mackinac, would never indicate my disgust for you as a human being. I have the utmost respect for your career. I do, however, differ with some of your handling of matters, one of which is your live stream. And you are aware that I took an opinion about that the last time I was here. I still come to court when I can. I was brought in here to handle circuit court with the idea that this office might be able to get back where it should be before the last prosecutor dismantled things with his blatant accusations against my present boss. That's why I'm back here, because I believe in this prosecutor. I believe she's the first one you've had in a while that wants to do the right thing. And the right thing just like it was the first time I was here for a while, was to hold the people that are putting a huge burden on the citizens in this community, to hold them accountable. My anger and my disrespect was directed towards a feeling that I have that this court expects a lot of its prosecutors to be here, to just wait, to address things that, as I just conveyed to the chief judge, one of the few counties I've ever been in as a prosecutor or a defense attorney where prosecutors appear routinely at sentencings. It just doesn't happen anywhere else. Why? Because they're busy. Well, we're busy. We have 3 people. One of them is the elected prosecutor, the newly elected prosecutor, who has her hands full, just trying to correct the errors of the past year. That leaves me handling circuit court and helping out in district court, while Mr. Robert is helping out in district court and also spending a lot of time in Three Rivers. So yes, there is a lot of pressure on this office. Did that enter into my feelings of disrespect for how this system operates? Yes, it did. It was never directed towards you, Judge Middleton. There are times when I lapse and I have to think to myself to say Judge Middleton, because we've known each other a long time. I will, if I can, be honest now, not that I haven't been up until now. You will recall that while at that prelim, I came in here and I advised the court right away that I had been working and trying to get Mr. Truckee to let me know whether Mr. Fuller was going to waive or not waive, that I had talked to Mr. Truckee about what would happen if I'm going to have to bring officers to come in and sit as what you call kind of so what case. Well, they came and they waited and they waited and we waited. I looked at this young man's record, this 34-year-old man, and I saw bench warrants just like this on the Walmart case and the stolen car case, where he was supposed to be here. And ups, it got adjourned, come back. I think Rhonda Ives, nope, no bench warrants issued. In this situation, what happened from our perspective that day was I appeared at the prelim. I respectfully laid out why I thought it was appropriate that his bond be canceled, that a bench warrant be issued so that he could be brought before the court. And I knew he was going to get another bond, or at least we might find out, A, is he around? People assumed he was. I don't assume anything. All I know is he was supposed to be here. You did a bench warrant. I checked when you were gone because Mr. Robert pointed out the ROA was confusing, that it sounded like he was to be something about arrest, but the warrant was there. So I talked to Judge Pattison. We went to the district court. We clarified the day before he walked into court that the bench warrant was valid. Mr. Truckee had told him to go to the jail, and I knew nothing about him coming in here. Certainly knew nothing about him going to the jail. I knew nothing about him coming into the court when there was a warrant, and nobody in security notified us. What I was notified of was when my prosecutor walked in that morning and said, I just saw Kuran Fuller riding a bike or something down the street. What's going on? So I go up to security and they tell me, oh, he came in and Judge Middleton let him go. That upset me. It upset me because I thought that because of the respect that I've always shown in this court, my willingness to try to be here to do what I can to help out, that I would have been notified of something when I'm sitting in my office looking at my cases. I want to know why he wasn't here. That's usually what happens in circuit. They get arrested. Why were you here? Well, my mother was sick. Okay, we'll reinstate the bond. Something to impress upon people that the court means business. And that's all I ask as a prosecutor, that the message that gets sent through this live stream, through our appearances in court, means something. Not comments like on the record, well, it's not the crime of the century. Or it's a pain in my neck
He said he's. a
when this
pain in the neck,
happens. Pardon me?
Yeah, he is a pain in the
Right.
neck.
But he's more than that, Your Honor. He shows disrespect to you too. Your statement that you made about, well, it's more trouble to book you in and then book you out.
That's true.
It is. But that's the system that's in
Well, all
place,
right,
isn't it?
listen, I agree with everything you said.
And
What-
let me finish and then I'll take my admonition. I do not recall that you ever indicated or that I indicated a PR bond. I didn't know what happened. All I knew is you let him, they told me that you let him out. I didn't hear the court rule cited whatsoever. That I think would have been the thing that we might have done on the record had he been brought in and Mr. Truckee held here or held in the jail and held in lockup until Mr. Truckee got back, because I'm interested to know what kind of contact, if any, he even had with his attorney after he walked out of here. Those are the kinds of issues that go into my decision on whether I'm not going to use additional resources to just simply file a motion in front of Judge Stutzman and bring Ms. Ives in and bring everybody else in because of the multiple attorneys that get involved here. So there are a lot of things that I like to discuss. And I think if you talk to the chief judge, you'll hear that we talk about ways to try to improve the system, to try to make it more efficient, to try to make it work with just 3 of us. So yes, I was angry. Yes, I regret my comments to you, and I regret losing my temper. I don't want to be seen as that way, but I have been doing this for pretty close to 50 years, and I've seen it all. And I've been a judge dealing with parolees going back in front of me on the pro board. I know what it is to disrespect someone, and I feel bad that I did that, and I feel bad that I did it to somebody that I in the past considered a friend. I hope you will accept my apology for that and recognize that the frustration that I have is not because I'm lazy. It's not because we don't want to be bothered. It's because we want to try to make the system work for the people in this county, the people that are paying a lot of money. My last comment that I wrote down when you were talking is what you said about the court rule. And I will say, I don't have that memorized. I haven't really experienced that before. Nobody's ever cited it to me. The way it's been handled is what I just outlined. Come in, hear your story. Why didn't you do? Ask the defense attorney, what kind of contact did you have? Usually there's the admonition. I'm going to let you out. You're going to be in touch with your attorney. You're going to be on time, not 10 minutes late for court, like this morning.
We went through that.
Okay. And is he, not presumably with flight risk? Let's not forget that this case, in which he faces life or any term of years because of his past record, is right on the heels of a case in which he led law enforcement through this little town in a high-speed chase while he allegedly was carrying meth and a gun. So this man is bordering on heading into a lot more serious. And it seems to me, and again, I'm not going to go into comments that you and I had off the record about your past dealings and family's dealings with Mr. Fuller. But yes, I was upset because I have a perception that this is not being treated seriously. And for that, I apologize.
All right, your apology is accepted.
Thank you.
Within the week, Judge Pattis and I had a discussion just before I went on my trip about what an asset you were to the prosecutor's office. You can try a case in circuit court. You're willing to do misdemeanor pretrials. You show up at sentencing and do appropriate, thoughtful comments. And Judge Pattis and I both believe, I'm sure Judge Stutzman too, that you're an asset to your office. The office wouldn't function without you being there. You and I go back 45 years, which is in part why you thought you could come in there and unload your anger on me. Yes. we taught a generation of young prosecutors how to be a prosecutor, including our current Attorney General. But this case isn't the one to hang it on. Now, we'll have a drug test, and I have my suspicions of how that's going to turn out. And we'll have a prelim if necessary on Friday. When all the cases are in circuit court, perhaps you can file a motion to cancel this bond.
Well,
But that's up to Judge Stutzman, and he's got multiple counsel. I think there was an effort to try to do everything together. Anyway,
Your Honor,
I regret that this whole thing happened. I discussed it with the chief judge when he got back, said, how should I deal with this? I don't think it deserves a grievance. All I wanted was an apology, and I got one. And the case will move forward, and the defendant is here as under the court rule. And I said, nobody liked that court rule. It was probably the least popular in the whole criminal justice reform package, but I'm bound to follow the law. Yes,
you had mentioned the prelim on Friday.
excuse me, I'm sorry.
Okay, just want to make sure.
No, Tuesday,
Tuesday,
I don't want to make any further confusion. Tuesday, June 17th, 1 o'clock, Mr. Fuller, you're to be there at that time. I want you to go directly from me. Well, I'm all screwed up. June 10th, next Tuesday,
All be on the same
June
page.
10th, not the day we've been using for the others. I want you to go to the day reporting center right now, and we'll do 11 panel test. We'll figure out who's going to pay for it, but it'll be paid for.
Yes, sir.
Then it may take a few days to deal with that. We'll deal with the results of that at your prelim next Tuesday. All right, you're free to go. We'll let the day reporting center know that you're coming. Or will you call them and tell them Mr. Fuller's gonna stop there for a 11 panel urine test?
thank you, Your Honor.
Thank you, Your Honor.
This matter is completed. Let's bring Ms. Welch in and deal with that matter.
Already has concerns that she is detoxing. I did meet with her. They believe she's in her beginning stages, so she is a little fidgety
Would you,
and
well, let's see.
anxious, so.
She's positive for opioids and methamphetamine. If we wish to continue it, her family's here.
I talked to her about inpatient. She's
All right, I'm gonna